Good evening, everybody. This is a meeting of the House Criminal Law Subcommittee. Folks, please mute yourselves. Someone needs to mute themselves. I think it's Debbie Fine. Okay, there we go.
No, I am.
All right. Lisa Jordan, I think you need to mute yourself. Chris, can you force a mute on some? There you go. All right. Thank you, everybody. This is a meeting of the House Criminal Law Subcommittee. We have a very full agenda, and we are going to attempt to try and vote everything today in short order. We're trying not to do bill hearings today, so hopefully everybody's had a chance to review the legislation before us. We are going to go back to House Bill 496, Delegate Shetty's consent bill. I do believe we're further along on this issue. This was the bill to try and remove the force requirement and there on second degree rape. And there was a few amendments proposed, but I do believe today we are going to take up two sponsor amendments that seek to clarify and narrow the circumstances of this bill. Chris, can you put up on the screen the sponsor amendments for House Bill 496? All right. So this is the first section here, which I believe is this beginning on line 8. It adds a totality of circumstances, including words and conduct, slightly rewording.
Go straight so you don't waste time. We're the most important.
And then here is the new limiting section. Delegate Simmons, can you mute yourself, please?
Sorry.
Here on line 18, that the second degree offense requires that the individual knew or reasonably should have known that the victim would submit as a result of fear, threat, or coercion. All right, Delegate Cardin. You're on mute.
Thank you, Mr. Chair. I just wanted to ask to that new language that we saw at the top about the totality of the circumstances. That's
new, back to that?
New amendment, or is that shall be determined based on the totality of the circumstances? Is that new, or was that part of the original bill?
I believe it's a rewording, but Delegate Shetty, can you clarify?
Yep. Thank you, Mr. Chair. Thank you, Delegate, for the question. Yeah, this is a technical amendment that cleans up the wording of the bill as introduced. The totality of the circumstances analysis was existing in the initial bill, and it continues to exist in the amended version. This is a technical amendment that cleans the language.
I was asking because this is very, very similar to the language in my amendment. Is it not?
I believe your amendment was the second amendment that was pulled up around the known or should have known.
No, I have another amendment that I presented to the chair just today that says, when based on actions the perpetrator reasonably calculated to overcome the will of the victim and where the victim's submission is objectively reasonable in light of the totality of the circumstances.
If I may, Mr. Chair, that is a different standard, the objective standard. So it is different than the two amendments that
Okay.
I've offered.
Okay.
Great. So sorry, Chris, can you put the First Amendment back on the screen? Let's just be very clear about this. So it's a rewording of what was already in the bill as introduced about the totality of the circumstances. All right. Can I have a motion on this amendment? There's two of these.
Favorable, Madam Chair.
This
I
is the
mean,
first
Mr.
of-
Chair.
This is the first of two
Second.
sponsor amendments. All right. All in favor of this amendment, raise your hand or say aye.
Aye.
Does anyone want to be recorded in opposition to this amendment? Okay. Can we now flip to the second sponsor amendment, Chris? Okay. So this one is a narrowing amendment that attempts to put some sort of mens rea into this offense. Any comments or questions about this wording?
Move favorable, Mr. Chair.
I'll second.
Um,
Can I ask a quick question?
yes.
Okay, so the perpetrator knew or should have knows or reasonably should have known that the victim would submit as a result of fear, threat, or coercion. That's what we're discussing right now.
Yeah.
Okay, and we so that is and who that I'm just trying to figure out, like, how do we, that's a I'm trying to figure out from whose perspective this would be an objective perspective, right? As Delegate Shetty said before.
I mean, I suppose this is up to the trier. Delegate Bartlett, your hand just went up.
Yeah, I was just gonna say that, what this is getting at is whether or not there is consent. And it would be, I don't know if we would use the reasonable man standard or reasonable person standard, but it is up to the fact finder. Because it's basic, I read it to say basically that, if they knew or should have known that they were going to submit, then you can't use consent as, you can't say that there was consent.
Delegate Embry.
Thank you. This is a very friendly, I think, amendment, just in technical. Instead of saying should know that the victim would submit, could we say that the victim submitted, just for clarity?
I think that is, I would support that oral amendment to this. I think it reads better with it.
Thank you.
That's a little clearer to me. Let's keep collecting comment. Delegate Grammer.
Yeah, I'm apologizing late. Can you just read the amendment to me one more time, explain what it does?
If the individual alleged to have performed the act in violation of this subtitle knows or reasonably should know that the victim would submit as a result of fear, threat, or coercion, the bill would then apply. If the individual alleged to have performed the act in violation of this subtitle knows or reasonably should know that the victim would submit as a result of fear, threat, or coercion. Delegate Embry has further tweaked the would submit to submitted. In that reading, it's if the individual alleged to have performed the act in violation of this subtitle knows or reasonably should know that the victim submitted as a result of fear, threat, or coercion.
I'm sorry.
Move favorable on the amendment to the
Hold on,
amendment.
we have Joyce King and then Delegate Cardin. Joyce King from the State Attorneys, please.
Hi, can you hear us?
Yes.
I'm actually here with both the MSAA and Defense Counsel. So I'm going to speak as a group on this. I think we believe that legally it should be as it is written, would submit. Is that right? Yeah.
I agree.
That we should not change that language.
Okay, can I just ask a question then? Can you guys explain, can you explain how that operates? Is like, I just want to hear from the practitioner that that's actually a preferred and clear standard that people find justiciable.
So the relevant state of mind is what the perpetrator knew was prospectively going to happen. So it has to be would submit rather than what they knew after the fact. Submitted makes it after the fact. Does that make sense?
Okay. All right, and sorry, who do you have representing Defense Counsel there? You're like a little tiny little dot on my screen. Sitting in the back of the room.
Christine and Mimi Tehan on behalf of Maryland Criminal Defense Attorneys Association, and I agree that is actually would be an element that the state would have to prove about the intent prior to the act.
Okay.
Mr. Chair, for the record, Lisa Jordan from the Maryland Coalition Against Sexual Assault, and I'm a lawyer and also agree with the other lawyers in the room.
And I forgot to put my name on the record, Debbie Feinstein from the MSAA. Thank you.
Okay, Delegate Cardin.
Thank you. I like this amendment. I will vote for the amendment. I just want to make sure. So in my scenario that I gave last time we met, so there's two inexperienced people who have been active but not necessarily had intercourse, and they go and they start experimenting, and one freezes, and the other they've been together multiple times, but never having intercourse, and now the one who freezes regrets it and is interested in pursuing something. Are you able to or interested in pursuing based on this language, or it's just not even going to be a suit? That was really for the MSAA and the defense bar.
No, I think under the fact pattern, and we can speak as a group here, but under the fact pattern that you give, we would not be able to proceed because in that scenario, the individual did not have the reasonable belief that there was no consent. So it's through the lens and the perspective and which we articulated, I think already exists with general intent, but this makes it explicitly clear, as Christine stated, that we would need to, there would need to be evidence and indicia of proof that the defendant or the accused was overcoming that consent.
And in that fact pattern, it doesn't seem, given the acquaintances and knowledge of both parties, that he would reasonably believe that she would freeze up.
Correct.
Under that fact pattern.
We wouldn't be able to prosecute it.
Okay, Delegate Grammer, and then we're going to wind it down. If all the parties are agreeing to this, I don't really see that we have much reason to stand in the way. Delegate Grammer?
Yeah, thank you, Mr. Chair. I just wanted to make sure I heard correctly. The advocates like the language that we're looking at right now. Is that correct?
Yeah, everyone's asking us to take the language on the screen, so that
I
would
see
be my
thumbs up,
recommendation.
so move the amendment.
All right, is there a second?
Second.
All right, all in favor of that amendment, raise your hand or say aye. Anyone opposed?
I mean, I'm not opposed, but I'm in favor of it. I was on mute though.
All right, would anyone like to be recorded in opposition to the amendment? All right, now the bill is before you with two amendments.
Move favorable.
Second.
Wait, we've got Joyce King with a hand up. Are you
Oh.
trying to stop the train?
Okay, thank you. Just to be clear, delegates, we appreciate your consideration of the amendments, and we think the amendment defining the consent is good, but the Maryland Criminal Defense Bar Association still objects to the elimination of force or use of force. We think you can move forward with keeping that language, having this brand new definition, expansive definition of what consent or lack there is of, and see what shakes out before eliminating such a specific element that would truly change in my mind, in our association's mind, the 4-tier system of sex offenses in Maryland. So I just want to be clear that that's our position.
Thank you very much. Did Elizabeth Hilliard for OP final word?
Thank you. I just want to say I drafted an amendment that I thought that I said before that I prefer. I think that language does it. I know you're not taking that under advisement, but I would be very much happier with that amendment, but that's okay. Just want to make sure that's clear.
Understood. OPD Hilliard, one final quick word,
Just, we agree with Christine, OPD's petition, Ms. Dufour and the Maryland Criminal Defense Bar.
Understood. All right, we have a motion and a second. All in favor of this bill, HB 496 as amended, please raise your hand.
Aye.
Would anyone like to be recorded in opposition? Okay. Thank you very much. We're going to move on to House Bill 597. This is a departmental bill, the GAPS Act, police apprenticeships, and the like. I do believe we have departmental amendments that have been worked out with the stakeholders. Can we put those on the screen? And while we have them up, would someone from the administration like to tell us what we're looking at?
Yes, hi, good evening, everyone. Miles Hicks, Deputy Legislative Officer for Governor Westmore. What you have in front of you today is a bill. Nothing, the purpose of the bill remains the same as we had during our bill hearing, but you will see that we have made some changes to, specifically a lot of those changes have been made to the apprenticeship portion of this bill. We leveraged some connections in the Senate as well as with labor unions to make sure that all of their concerns were addressed. The biggest change you'll see is that we've created in this program what I'd call 2 pots of money, one for startup cost and the other for actual maintenance of an apprenticeship program. You'll see that Department of Labor can grant up to $200,000 to an organization that is starting up a public safety apprenticeship program, and they can also leverage $5,000 to keep that maintaining as well per apprentice. You'll also see language in here specifically around collective bargaining. Most of these folks who are establishing these programs are also unionized. So we want to make sure that if you do have to collective bargain to create a new role, that those agencies are taking those steps to follow those rules. Going on to the next section, you will also see there's been some slight adjustments. These recommendations came from MACO, just to ensure that, you know, we are seeing workforce issues in our law enforcement as well as in our correctional facilities. So this would just add correctional facilities and representatives from correctional facilities as well as from an appointee from the Senate President and the Speaker of the House as well to the bill. And finally, again, towards the end of the bill, you will see, again, some uncodified language, again, just making sure that we're looking out for our friends in labor to ensure that we're following all the collective bargaining processes that are currently in place. More than happy to answer any questions that you guys may have.
All right, does anyone have any questions on these sponsor amendments? Can I have a motion on the sponsor amendments?
Move the amendments.
Second.
All right, all in favor of the sponsor amendments, raise your hand or say aye.
Aye.
Is anyone opposed? Boucher, you're not opposed, right? Yeah, okay, great. All right, great. So we have adopted those amendments. We do have an additional amendment from Delegate Grammer. Would you like to press it? This is to add his police quotas bill to the governor's bill.
Yeah, I'll be very brief. Thank you, Mr. Chair. So this amendment is a modified version of House Bill 6, which tightens the language around the use of quotas for arrests, citations, warrants, etc. I like the bill as drafted, as amended, but in reality, it doesn't do a lot to help police. And this is one of the few issues we actually hear from front and center, frontline officers that really damages their ability to serve the communities where they're assigned. It takes away their discretion. And, the kicker was that every time we talked to state police about the use of quotas, one name came up, Roland Butler, who is now head of the state police. The media asked Mr. Butler about his use of quotas, and he says, I don't think we should use quotas. So seeing that we're all in agreement here, I think we should tighten the policy. I will note that we have quite a number of members of this subcommittee as sponsors on the legislation. And I've listened to the people who've had concerns about the bill. If you go to the top in the uncodified language, we've dealt with the problem or the question that people had around the ability to use use the data regarding arrests without using quotas as a matter of policy. So in other words, in disciplinary actions and looking at performance, we'd be able to look at the data as long as we didn't actually have a formal policy of quotas. So I think it's good policy. I think it's something that would really enhance law enforcement and make officers really feel that we have their backs, restore discretion. So I would move the amendment.
All right, he's moving his amendment. Is there a second?
For purposes of discussion, I'll second it.
Sure. All right, we're on the amendment. Very briefly, I hope we don't take too much time talking about this. I would urge you to resist the amendment. It's a separate bill. As you know, many of us actually do support what the delegate is trying to do in this bill, but I don't think this is the appropriate vehicle to do this on, but I appreciate the effort. That being said, all those in favor of Delegate Scrammer's amendment to add his bill to the governor's bill, please raise your hand. Okay, we've got two on, Sandy's raising his hand, but he's not in the committee. All right, we've got two on that one. All opposed to that amendment, raise your hand or say aye.
Aye.
Okay, that's the rest of us. Thank you very much. All right, now we're on the bill amended and unamended. Do I have a motion?
Move favorable, Mr. Chair.
Second.
Wonderful. House Bill 597. All in favor, please raise your hand or say aye.
Aye.
Would anyone like to be recorded in opposition? Great, thank you very much. All right, we're going to roll on to House Bill 1209. This is Delegate Cardin's bill updating paraphernalia penalties. Delegate Cardin, do you have a sponsor amendment?
I do have two amendments, Your Honor, Your Honor, Mr. Chair. I did get a call from the State Attorneys Association asking me to hold the bill because they didn't see it on the list. I told them that you were going through all these, but I would just let you know. And I did send them a copy of the amendments. So
I'm going to tell you what, I'm disinclined to do that. This bill has been in the works for many years, and this is the smallest. So just so you guys know the history of this, there was a full-out syringe decriminalization bill. It passed many times, got vetoed, and just fell a hair short. And after years, Delegate Cardin has come forward with a very, very, very modest bill that just adjusts the penalties downward for this, which is something Scott Schellenberger suggested from the outset many years ago be the road we take. And here we are years later taking that road. So I'm disinclined to take the state's attorney's advice on this, but I can tell you this is just a subcommittee recommendation. We'll get them the reprint and give them full opportunity to comment on whether they think we've improperly translated what they would agree to into writing. Okay. I think it's entirely fair. But with that, can we put up on the screen what it is we're talking about?
Which amendment would you like first, if you have the number?
So I have, I don't know, am I not on Zoom? I have three different amendments because it came in a little disjointed. You
have a reprint you can show us.
Do we have a reprint?
We do, but I only have two. but if you give us the number for the third that we're missing, Claire can pull it up and pass it over to me.
Okay.
1 second.
All right, so what are we looking at here?
Right, so, Mr. Chair, the first part of this bill, it basically goes to section 619 and reduces the penalties from 2,000 to 1,000, which would be commensurate with the actual possession of the narcotic, and it makes paraphernalia the same penalty as the narcotic itself.
On the subsequent offense,
On
correct?
the
Okay.
subsequent- the subsequent offense.
So does that make sense to everyone? Regular paraphernalia right now is first offense fine, second offense 2 years. And this would bring that down to first offense fine, second offense 1 year. So 2 years to 1 year for a second offender whose crime was possession of drug paraphernalia. Okay, can you keep going?
The Second Amendment eliminates the word administer, and the idea of possession out of 620, so that we are not penalizing people who are merely possessing the paraphernalia or administering it to themselves. The distribution of controlled dangerous paraphernalia or paraphernalia for controlled dangerous substances is not at all affected, and that is the major amendment in this.
Okay, so does everyone understand this? Under Maryland law, there's drug paraphernalia, and then there's controlled paraphernalia, which comes in with a 4-year penalty. And in that 4-year penalty, Delegate Cardin is deleting possession and use words like administer, and leaving the crime and the higher penalty for the rest: distribution, dispensing.
And it remains at 4 years for possession of paraphernalia, controlled paraphernalia, if it's for the purpose of, as defined by controlled paraphernalia, for the purpose of manufacturing or distribution of the controlled dangerous substance. We're not reducing that penalty, even though originally the bill did. We're taking all that out.
Okay. Should we flip to the other amendment now?
It is. Let's just see. Yes, it is Amendment 323928/1, Amendment number 1.
What are you doing here? Okay, so in controlled paraphernalia definition, again, that's the higher 4-year penalty category, he's deleting syringe.
That's exactly what I'm doing. Thank you for.
So as I read this, the bill now moves syringes from controlled paraphernalia, where it's a 4-year penalty, into regular paraphernalia, where it's a fine and then jail up to a year on your second offense. The old effort that went for many years was just trying to fully decriminalize syringes.
Right.
So, all right, that's 2 amendments. Can we put them together as one and take a motion?
I'll move the 2 amendments.
I'll second.
All right. Yes, Ann Seacott.
Hi, Ann Seacott, representing the Baltimore Harm Reduction Coalition. I want to say that on behalf of the coalition that we think you all have had it right for the last 3 years. And, we're sorry that the former governor vetoed it when it got through the Senate, and that the Senate hasn't revisited it as you have. So we want to just acknowledge that. Thank you very much for your work. And, while, we are not happy to be going with something less than what you've done before. We are appreciative of the efforts of you, Mr. Chair, and Delegate Cardin and other supporters.
All right, thank you. So we have a motion and a second. All in favor of adopting the sponsor amendments, raise your hand or say aye.
Aye.
Would anyone like to be recorded in opposition? Grammar, okay. Sorry. Do we still have Eric Hand? Might not. Okay. Now the bill is before you as amended. Can I have a motion?
Favorable.
A second.
All right, all in favor of House Bill 1209 as amended, please raise your hand or say aye. Would anyone like to be recorded in opposition? All right, two no's, Grammar and Eric Hand. Thank you very much. We are now going to, oh, and Delegate Cardin, will you please send a reprint over to MSAA ASAP? I want to make good on giving them the opportunity to object before that hits the voting session.
I will work on that right now.
Thank you. All right, we're going to flip over to House Bill 203. This is another departmental bill about local opioid reporting. There were some amendment requests. Do we have someone from the administration to explain where we're at on this? And if not,
this is Bethany Young from GoCap.
yes, great.
Yes, so it's the original bill is ours, and I think Mako is on still. It's
Yep, I'm here.
Yeah, there's an amendment from Mako, and I think also an amendment from NCADD. Are they on? Yeah, oh, and there you go. So the bill as written is pretty simple and straightforward. If Delegate Moon, I can hand it off to Mako and NCADD if you think that's right to explain the amendments.
Do you want to just give us the 5-second synopsis again of the bill?
Yes, I can do that. So the bill basically eliminates some of the duplicative reporting requirements placed on jails as it relates to the medication assisted treatment program as outlined in section 9603 of the Correctional Services article. The reporting requirements we're asking be stricken are captured by other elements. They just kind of repeat themselves. So I think there are 4 elements that we're asking to be removed from the statute as required because they are captured by other elements of the jails report.
Great. And so before we talk to the advocates and lobbyists, are you opposed to the Mako amendment or the NVIDIA amendment? I believe the Mako amendment was for money.
Yes, I think my colleagues at Health should answer that question. Marie Grant.
Thanks, Bethany. Delegate Moon, I do think we have concerns about the Mako proposed amendment. You all actually have a different bill before you. And Sarah should explain her amendment from Mako, but you all have a different bill before you, House Bill 1031, which deals with funding for Medicaid-assisted treatment, and it is a policy discussion. It does have fiscal impacts, and so we would ask to respectfully dialogue on this particular issue in the context of that bill.
Okay. So that sounds like they don't want us to take the amendments, but we have our friends here to explain the amendments. Why don't we start with Mako?
Yeah, so quickly, I can just go ahead and explain the funding amendment. So our amendment requires MDH to fund the medicated-assisted treatment programs in the local detention centers with opioid settlement funds or through an appropriation. So whichever one they deem appropriate. When it comes to any conflicts or complications that arise in terms of the settlement agreements, we've confirmed with OAG that as our amendments are written, there are no conflicts with the national settlement or the subdivision agreement. And then my other concern just about the fiscal impact potentially for MDH, and Maria and I have spoken about this, we spoke about it this morning. When it comes to the fiscal note, which I think ended up being about $170,000 on the other bill, which is for identical amendments. Essentially, the Opioid Operational Command Center was absorbed by MDH, which was the agency already managing this process for the grants and the funding distributions and the reporting. So they absorbed the staff that was already doing that, and our amendments specify that the funding is done as a reimbursement. So it's actually less onerous on the state because this piece of it is no longer a grant procedure. It would be a reimbursement process. So those were just some of the things that we had spoken to MDH about and just wanted to share with the subcommittee.
Got it. Thank you. Did anyone want to speak on the video amendment? Eric Galley, go ahead.
Hi, Mr. Chairman. We're just including a class of drugs that a newer class of drugs that wasn't that prominent in 2019, but we're just adding them to the list. So it's adding a little bit more coverage.
And sorry, just to clarify again, the department does not want this on the bill.
So for the Department of Health, Delegate Moon, I don't know that I've seen Mr. Galley's amendment on this particular issue, but so for this one would defer to my colleague Bethany. But
yeah, I'm sorry, I don't know that I've seen
put
Mr.
it on the
Galley's
screen.
amendment either.
I apologize. Which amendment?
This is Eric Galley had sent in a amendment, or it's in the testimony packet actually. To add a additional, yeah, here we go.
3 words. It's just adding another option.
Yeah, it's essentially broadening the options.
So for GoCap, if some form of funding gets passed in the bill, we'd support this additional requirement. I mean, I think short of the locals getting the funding they needed, it would be hard to ask them to do more.
We would actually agree with that. We wouldn't want this to pass without the funding is the most important thing.
Got it. Okay. Well, I think that answers our question, unfortunately.
Can I ask? Mr. Chair.
Yes.
Just along the same lines as Mr. Galley's amendment. Is the cost for that new drug that's out now, that's available, is it exorbitant, like really expensive or not? I was just curious if it's along the same lines as the cost of the ones that the counties are using right now for the programming.
Does anyone have an answer to this one?
I can at least weigh in. So my understanding is that some of the long-acting injectables, they're a lot better in terms of trying to avoid diversion in the detention centers, but they are a bit more expensive. But yeah, that's the perspective from MACO.
Yeah, we have heard that folks would like to use them because there's the rest of the other medicines get shipped around and get used as contraband, but probably not widely.
Okay, thank you. I just wanted clarity when we were on that subject. Thank you.
Bethany from GoCap.
Yeah, Marie, can I ask you to clarify, is Health's position in opposition to the MACO's amendment entirely, or the amendment kind of as it's currently written? Is there any version of that would be palatable?
So to back up a little bit, and really, I think the policy for this is in a separate bill. I think appreciate that this is a departmental for GoCap on reporting. The Secretary of Health has actually been in discussions with MACO and is in the process of making decisions on opioid restitution funding and is interested in helping to support the counties in that effort. I think heard that plight. This is an important area to provide some funding. What MACO's amendment would do would be to require the entire cost of that to be provided through the opioid restitution fund or a general fund appropriation. And so I think either way you slice it, there is an over 11.47 million. I'm looking at the special fund expenditure on the other bill where this is dealt with, House Bill 1031. So that's about the cost of what the counties estimate to cover the current costs of their programs today. Now, if you're to add costs for other drugs, and I think the way Mr. Galley's amendment reads is that it says shall, and each local detention facility shall make these drugs available. And if we don't have good information on the costs, I think we can anticipate that that would be a more expensive cost. So I think we are concerned about the amendment, generally want to support the counties, but really feel that the debate on it should take place on the other bill.
Right. And the only thing I would add is that we had adjusted the amendments originally after talking with MDH to make it more flexible so that it wasn't coming out of just the ORF. It was going to come out of any opioid settlement funds or general funds. So it gave the flexibility to do one or the other.
Great. Guys, I think we got to take it straight. Can I have a motion on the bill?
So moved.
Move favorable, a second.
All right, Ann Seacott, you have a final word here?
I'm sorry, we had an additional amendment.
An
That was,
additional amendment?
yeah, it's in there. It's on your document. It's uncodified language, really looking at the future funding, which hopefully gets us past all of this at some point. And it's to say that the local facilities need to be working with their healthcare contracts to be able to work these costs into their healthcare contracts. Substance use disorder treatment is not special. It shouldn't be additional or luxury kind of service. It is healthcare, and it needs to be built into the healthcare contracts. And then we can stop eventually at some point needing the special funds to fund this. So that's what that language is. And my apologies for it not referring to the current name of GOCAP.
Well, I'll throw this back at our departmental bill sponsor friends. You want to give this one a thumbs up or a thumbs down?
The same as with Mr. Galley's. If there's no funding included in it, I wouldn't want to add an additional requirement. Or GOCAP wouldn't.
This isn't adding any funding. This is directing the local facilities to work with their local the healthcare providers, the people that contract with, to work this into their healthcare contracts.
I hear that. My understanding, based on some conversations I've had, is that kind of any additional requirement, which this would require local facilities to enter into new contracts potentially without accompanying funding. I don't think they can make that happen without dedicated funding.
I would add, it's not as easy as just rolling it into what we have existing, and the funding further complicates that.
Okay. I'm afraid I think we're still taking it straight. Delegate Grammer, do you have a final thought?
Yeah, I just wanted to ask the department, this is all 100% duplicative information. We're still going to have everything we need here with the bill as drafted.
Yes, if it's helpful, I can walk you through what's
Briefly.
where else is captured. Okay, give me 10 seconds. Okay, so if you're looking at the bill, starting on page 5, so item number 5 in the list of requirements is captured by item 1. So item 5 requires facilities to report the number of incarcerated people diagnosed with OUD. Item number 1 requires facilities to report the number of incarcerated people diagnosed with mental health disorder, an OUD, or a non-opioid substance use disorder. Item number 8 requires facilities to report the number of medications and treatments for OUD provided by type. That is captured by item number 4, which requires facilities to report the type and prevalence of medication provided. Item number 11 requires facilities to report the number of incarcerated individuals who initiated treatment with medication. We are able to determine that by a combination of the responses that are provided to item number 1 and 3. in that list. Item number 14 requires facilities to report the number of incarcerated individuals receiving medication or MAT for opioid use disorder prior to release, and we can use the information captured by items number 4 and 13 to get to that answer.
All right, Delegate Erican.
Yeah, thanks. So thanks for going through that. I'm just looking at the bill really quick. I don't know if my box probably just disappeared. Can you still hear me?
Yes.
Okay. So the only one that makes me a little uncomfortable is on the top of page 6, the number of incarcerated individuals who initiated treatment with medication or medication-assisted treatment for opioid use disorder who were not being treated for opioid use disorder prior to incarceration, because that speaks to the potential of incarcerated individuals being exposed to potentially opiates after they've been incarcerated and then initiating treatment after they've been incarcerated. I think that's information that we should probably continue to collect. And I do think it's different than the combination of 1 and 4 that was mentioned earlier. I don't think that 1 and 4 are going to catch those specific people effectively that may have only developed an addiction post incarceration.
So it's not, item number 11 is not necessarily capturing a new addiction. It's about the commencement of treatment, the timing that treatment began.
Yeah, I see that. So, but it would still potentially speak to if we have a problem with drugs coming into our system. You know, if we've got a large amount of people that are initiating opioid treatment a year after they've been incarcerated, you know, that's a problem. I think that's data we might want to have.
So I think there's an explanation that will satisfy you. I am reporting information that I get from my data people. And so I can't give you the more nuanced explanation that you're looking for, but if you give me, and I realize you guys are voting on this tonight, but I can give you a more in-depth explanation of why it is captured if you can give me like 12 hours.
Well, we can't give you 12 hours. Well, we can give you 12 hours to give Erican the answer, but we're not going to give Erican 12 hours to vote. How about that? All right. Well, I believe we still have. Do we have a motion in a second? If we don't, let's redo it.
Move favorable.
Second.
All right. The unamended bill 203. All in favor, raise your hand or say aye.
Aye.
Would anyone like to record in opposition? Wonderful. Wonderful. Okay. Well, thank you very much, everybody. We're going to move on to House Bill 892, Delegate Kaufman, benefits trafficking. We do have a Claire amendment, I believe, which is a starting point for this. It was taking a MSAA request for amendment.
And I'm fine with it, Mr. Chair. I consider it a friendly amendment.
And we have an additional sponsor amendment. We have an additional DHS amendment. And then we have 2 amendment requests from advocates. I am hoping we can do this quickly because the folks interested in this bill have moved onto the same page with which of these amendments they want and don't want. So with that, why don't we start with this? Delegate Kaufman, can you give us a 5-second explanation again of what this bill does?
Yes. What has been happening is that people with disabilities and older adults are getting exploited with the promise of care, but people are swindling them out of their SSI or SNAP benefits. And I'm very honored, just very briefly, Mr. Chair, that Delegate Munoz and Delegate Erican have joined me as co-sponsors.
Wonderful. So we had a sponsor amendment to add in additional benefits. We had a MSAA amendment. Can we put that one up on the screen? And if Claire is able to explain what that amendment does. Yeah, right. It's just written in code sections. That would be awesome. Claire, are you with us?
Yes, I am. I'm just reading through and trying to study it.
Not a problem. Take your time. And I'll try to pull up the amendment list on my end too.
This is they wanted it to be out of the human trafficking subtitle because they didn't feel like it was actually trafficking, that it was more of an exploitation type of crime. So it's just putting this crime, renumbering this crime as 3-1301. Or I mean, sorry, taking it out of 3-1301 and making it 8-524. And that's putting it in like the exploitation subtitle of the criminal law article.
Oh, I thought it was.
And that's the point about exploitation is actually raised by some advocates. So let me just quickly throw this out there. Does the sponsor or any of the advocates interested in House Bill 892 have an objection to the state's attorney's efforts to recodify this into exploitation?
Well, Mr. Chair, if I could first, I would prefer that it stay trafficking. However, it's late on crossover week, and I do not believe in making the perfect the enemy of the good. So I'm fine with it passing in either posture. I just want it to pass. However, it's my strong preference that it stay trafficking.
Is this bill cross-filed?
No, it's not, which is all the more urgency. So if the committee needs to make it exploitation to have it pass, then that's fine with me.
Do we have anyone with us
Yes.
that felt strongly about this being exploitation?
Can I comment, Mr. Chair?
Is that Delegate Grammer?
Yeah, we have Amanda Rodriguez from
yes.
Turnaround with us, if we could yield to her.
Yes, very, very briefly, please, folks, if we can.
Yeah, absolutely. Thank you, Delegate. Yes, the Maryland Human Trafficking Task Force, and I believe several other advocates testified that it is exploitation. It's not trafficking. It's missing one of the elements of trafficking, so it just makes it confusing. And without that element of labor or services being offered. So yes, we would object to it being trafficking.
Just to be clear, you like the amendment, Ms. Rodriguez, right?
Correct, yes.
All right, Sarah Miki.
Hi, yes, I just wanted to echo what Amanda said, and I appreciate the delegate for bringing this important bill. We represent HANA, which is the organization that originally kind of had this idea and talked to the council person who brought it to the delegate about this, but our intent was not to have it in the human trafficking statute. Thank you.
All right, Delegate Roberson and then Grammer.
I'll withdraw.
Okay. Delegate Grammer, is your hand still up or are you?
Yeah, I just wanted to say briefly, I think this is a technical correction, which is very much in the spirit of the bill. And this seems like one of those issues, if not corrected, could derail the bill. So I'll let somebody else make the motion, but I support the amendment. I think it's just a technical fix.
Before we vote, can we give 30 seconds to the person from the mayor's office that prefers the trafficking definition? I think she wants to say something very quickly.
Go ahead.
Kim, if you could get on.
Hey there. Hey, everyone. So one of the reasons why we did push for this being trafficking is to not necessarily because it fits better under exploitation, but differentiating between two types of exploitation. One that is more systemic and a developing form of human trafficking across the country. So we're not talking about the niece or nephew or grandson or daughter or son who is exploiting their grandma or their parent financially. This is literally speaking to those institutions that are buying and selling individuals for their benefits. They are giving families lump sums up front to have their benefits legally changed over. And we do have multiple cases that have been reported from the health department, from the Maryland Disabilities Office, where they don't have sufficient legal or criminal charges to pursue those businesses, so the licensed facilities that are buying and selling individuals specifically for their benefits. And so a lot of other states are starting to modify their criminal law to match this form of human trafficking that is starting to pop up all across the country. However, this would not apply to, again, those smaller types of exploitation where you have a family member who is taking advantage financially of a loved one who receives those benefits. And so that's why we feel really strongly that this should remain a form of human trafficking, which will also push for better investigations within law enforcement and in addition to prosecutions, which we've spoken with both Baltimore City Police Department, who are in agreement with this, and the Baltimore City State's Attorney's Office, as well as the state's attorney from Howard County.
Okay, colleagues, there you have it. So there's a slight disagreement on how to codify the request from the sponsor in this bill. But we do have to make a decision today. Delegate Grammer?
Yeah, I was just going to reinforce my previous comments. I think this is just a technical fix, and my sense, having done this a few times, is this is going to be a problem for the bill if we don't adopt it. So respectfully, I'd move the amendment.
Claire, do you have clarity you'd like to add?
Yes, I just wanted to comment that I noticed that I made a mistake when I was drafting that amendment, that if this amendment is adopted, we would need to fix the title of the bill and the purpose paragraph so that it would read benefits exploitation instead of benefits trafficking.
Got it. Okay, so we have a motion.
I'm going to move that oral amendment.
Great. So we'll just do this as a bundle then. Again, this is the previously drafted MSAA request amendment with a title change tacked on orally. We have a motion and a second. All those in favor of adopting the MSAA amendment, raise your hand or say aye. Is anyone opposed?
Me.
All right, the sponsor doesn't like that. All right,
but I'll live with it.
We have additional amendments. Both the sponsor and DHS, I believe, have amendments to add in additional benefits into the scope of the bill. Stop me if I'm wrong on this. Can we see those?
Well, I think this is the bill, not the amendment. Oh, there we go. Yeah. Here we go.
All right. Is there any objection to adding these additional benefits into the exploitation?
I move the amendment.
For a second.
Then.
All right. All in favor of adopting the sponsor amendment, raise your hand or say aye. Is there any objection? Okay, we have a DHS amendment that I believe also further expands the benefits in the bill. Does anyone object to adding these benefits into the bill?
Move the amendment, Mr. Chair.
Second.
All right, all in favor of adding these benefits into the bill, raise your hand or say aye.
Aye.
Is there any objection? Okay, great. There's one more amendment request, I believe, and it was a coercion request. I'm not sure who requested this, but if you're here, would you like to explain it?
think that was the one from Turnaround, Delegate Moon. So the concern that I had in addition to the exploitation definition or title language is that there are now going to be two definitions of coercion. I would be much more concerned if this was included in the trafficking section because it actually changes the definition of coercion in the trafficking language if it were to have stayed that way. But currently the coercion language that's in statute, the definition was developed looking at all 50 states, doing a 50-state scan of what was considered coercion and then applying that to our labor trafficking law. So for this amendment, again, it's less of a concern now knowing that it's not going to be in the trafficking section, but I still think it could potentially be confusing knowing which definition of coercion to apply. The language is similar, but there is more included in the current language. The other, the definition, it looks like that was pulls from the current labor trafficking definition. But again, that one is more expansive than the one that's currently in this bill.
So I'm personally going to have a little bit of a difficult time trying to sort this one out in the next X minutes. Are you suggesting to us that it's not important, it's not mission critical that this amendment get adopted with the other change we just made?
Correct. That would be correct.
Okay. So I think we know what that means. We have an amended bill before us, colleagues.
Move favorable on the bill.
Second.
I think Claire has her hand up.
Claire.
Sorry, I just forgot to lower my hand.
Okay, great. So all in favor of the bill as amended, raise your hand or say aye.
Aye.
Would anyone like to be in opposition? Wonderful. Thank you very much. We are going to move now to House Bill 145. This is Delegate Pippi's bill.
Evening, Mr. Chair.
Hey, so I did a little bit of work on this one myself, after just sort of trying to talk through this one. This was about deepfake and simulated pornography, where you might cut and paste someone's head onto a different body or pornographic video or computer generated. Can we have folks mute themselves?
Mute.
Pippi, you might need to mute yourself for a hot minute. Thank you. So the bill came in seeking to add deepfake and simulated porn where you stuck someone's head on another body into the revenge porn statute, which carries, I believe, 2 years. I batted this around and started reading about some of the civil measures, and IP ways people are trying to handle this, but was fairly persuaded that we could make a case to bring this into the criminal realm. But I have drafted an amendment, Chris, if you want to pop it up on the screen, that would move this from the revenge porn section into the harassment section. And here's my reason. It's simply that I think if you have and release actual nude imagery or videos or photos of someone, that is a very serious breach of trust, and a pretty serious offense. And not cartooning, but generating a fake one might be criminal, but seems slightly less than someone who did an actual revenge porn offense. So I will just throw that out there. And so I had this redrafted, the bill's intent redrafted into as a form of criminal harassment to stick someone's head onto someone else's body and publish that. And so, Chris, can you scroll down to the penalty section of this? And this bill is also not cross-filed, friends. So I think we might want to ease into this one. Where is the penalty on this? No, I think that's as introduced. There we go. 100. It's 180 days. So 6 months. Delegate Bartlett and then Cardin.
Thank you, Mr. Chair. I don't know if we have OPD here, but I do remember on the bill hearing when OPD came in, there were some concerns that are close to what you have mentioned, Mr. Chair. And while I don't think they would necessarily be favorable, I think you did a good job of trying to, bring in, oh, good, we do have OPD here, but I think you did a good job of bringing in some of those examples that were provided in the hearing on the what ifs. So I think you've kind of, gotten to those what ifs. So that's all. Just thank you.
Delegate Cardin.
Thanks, Mr. Chair. I'm only firing on like 2 cylinders right now. So you're making it a higher penalty or a lower penalty by moving it to the harassment side instead of the revenge porn?
Lower. And my theory is if you have, so revenge porn would come with 2 years. I have actual imagery of you and I put that out in the world. That's currently a 2-year offense.
The only thing I'll say is that how does other people know that it's not a real image? I mean, as far as the viewer is concerned, it's an actual real image in theory.
I understand the technology, and I guess I'm just suggesting to you that it seemed fair to me that these are slightly different offenses, potentially still criminal, but I do believe we would be moving into a new world, moving this simulated imagery into the criminal realm. Delegate Grammar.
Thanks, Mr. Chair. Just curious what the bill sponsor thinks here, just to stir up the discussion.
Delegate Pibby, do you want to pipe in?
Sure. I mean, look, Delegate Moon has over the years done a good job at trying to find a compromise between the different parties that have concerns. I think the majority of folks realize this is a problem that needs to be addressed. I think by moving this area into a different part of the code and then reducing the penalties is an effort to strike a balance. While I prefer to have the more stringent penalties, we definitely
We lost you, Jesse.
Can you hear me now?
The last part again.
I can still hear.
Yeah. So long story short, it's a compromise and we want to move the needle forward. I think that's what Chair Moon is trying to find is a compromise that somewhat satisfies everyone's needs. We're obviously not opposed to the amendment because it still addresses the situation as best it can be. And I think he's trying to find a compromise with some of the parties. So that's my take on it. It's an important issue. And I think Delegate Moon is doing his best to find a compromise with all the different stakeholders. So
is there any of the stakeholders that don't feel that this is a legitimate fix?
No one's raising their hand. Delegate Boucher.
Thank you, Chairman. My only concern is the cartoons being listed. Does that potentially run us afoul of Supreme Court case law and parity?
It says they're not counted. The cartoons don't count.
Okay.
And if I may, there's some language in there about being indistinguishable from the real thing, Delegate Boucher, if that's helpful.
Okay.
Move the amendment.
All right. All in favor of adopt. Oh, sorry. Yeah, we did need a second. All in favor of adopting that amendment, please raise your hand. Is anyone opposed? Great. We did have an additional request. Lisa Jordan wanted to flag something before we vote this. Lisa, are you with us? She might not be with us.
Should I text her, Mr. Chair?
Yeah, well, and I'll tell you what she wanted to flag. She wanted us to remove a statute of limitations on this offense. I'm not sure about that. And I guess my question would be, what's the default statute of limitations on this if we don't specify that one doesn't exist? I don't actually know the answer to this question. So if someone here or council is aware.
Any misdemeanors, one.
Sorry, say that again.
Any misdemeanor is 1 year. The default is 1 year from the time of the violation.
And okay, great. And so Lisa Jordan had requested no statute of limitations on this offense. Delegate Roberson?
I seem to recall, because there was an issue during testimony that was raised as to the fact that sometimes you don't see what's posted, or they might post it a year after the fact. And so an individual might discover that an individual posted them on a site, you know, and it was 2 years after it was posted, or after the event occurred, they posted it 2 years later. And so that was supposed to be taken into consideration, and I might be missing it, but I think that was also a concern that's raised around statute. That might be why I, am not in favor of removing statute of limitations, but I think that's a way to address, we need to address that issue.
Well, we have to, if we want to handle this, we pick a non-arbitrary number. Erican and then Embry.
I'm just seconding what Delegate Roberson just said. I think we have to address that because the risk of us not being able to utilize the statute is high if we don't solve this problem before we move it.
Delegate Embry.
I just wondered, and this might be a question for Claire, if I think this might apply at any point that it's up and visible, in which case the statute of limitations would run from, the point that the person saw it, as long as it was still published.
I'm good. We're in a subcommittee there.
But I don't know the answer.
Okay, unless I'm bugging you here. Thank you, though.
Well, Lisa Jordan, can you hear us?
I can hear you. Thank you.
So we are. There sounds like there's support to throw some statute of limitations on here, and we need to quickly just stick something on here. Did you guys were you telling me you just did something on other offenses with the statute of limitations? Or we're trying
Yes, there was, I believe, the cross-file to, I believe it's House Bill 544 that they passed out of the Senate. And let me see if I can see exactly what the suggestion there was. I will say, however, that in that action in the Senate for revenge porn, which seems to be the corollary to the deep fakes, they said no statute of limitation for the revenge porn. And that is because of our experience with survivors who find the revenge porn. And I would think also the deep fakes many years later. For sextortion, the Senate reduced the statute of limitation to 5 years and for 10 years. So perhaps if you're looking for something in the middle and in the nature of progress and compromise, maybe 10 years would be appropriate in the bill before the subcommittee.
10 sounds long to me, to be perfectly honest. I was going to say 3 or 5. I don't know how other folks think. Claire?
Perhaps another option would be from the time that it's discovered by the victim. The difficulty is that we often find that these images are placed on the internet, and it's a long time before people find the images on the internet. So that might be an alternative for the members to consider.
Claire, did you have some clarity you wanted to bring?
I just wanted to mention that the Public Safety Subcommittee passed out a bill, House Bill 593. It was about destruction of funerary objects. And that bill, one of the main purposes of that bill was to extend the statute of limitations from the general 1 year limitations to, the bill came in at 5 years, but the Public Safety Subcommittee passed it out as 3 years from the time that the local authorities found out about this destruction in the cemetery. And the testimony at the bill hearing was that these people hadn't gone to the cemetery to see their loved ones' graves for a long time, or it had been more than a year, so they couldn't prosecute it. So I just wanted to, give you that information about the other bill.
So the funerary bill didn't run from statute of limitations, didn't run from the discovery of the crime. It ran from the date of the crime.
Well, initially, but as the Public Safety Subcommittee passed it out, it runs 3 years from the time that the local authorities find out about the crime.
Okay, that sounds reasonable. 3 years plus discovery plus 3 years.
Can I comment?
Yes.
Yeah. I don't think funerary object destruction really comes close to revenge porn. So I don't know. I think
it's not we're not doing revenge porn though. I want to be clear. This was sort of the point of the distinction of the amendment. We're now talking about simulated and deep fake porn. And I guess, but I guess the question is,
it's not different.
But when you find it on the internet, do we need more than 3 years to bring a case? I don't know.
It's deeply personal, and it may take a while for you to decide that you want to do something with it. So I think, if we want to come to a compromise, I think 5 years is reasonable. So thanks to Claire for bringing that bill in, because it definitely puts it in perspective. But I just, in my brain, can't wrap my head around the state of Maryland wanting to say the same exact essential statute of limitation exists for funerary objects and lifelike, real looking pornographic images that are intended to victimize people. Like, it just feels wrong to me. So I would be comfortable at least with a 5 year once they're discovered by the victim.
All right, Delegate Bartlett, and then we'll go to a quick OPD comment, and then we'll take hopefully consensus straw poll on the statute of limitations. All right, Delegate Bartlett.
Okay, I'll be fast. I'm just a me too on what Erican just said.
5. Does everyone want 5? Is that where we're headed?
5 is good for me.
All right, Roberson, you're shaking your head. What do you want?
I'll follow the will. I'm in the minority, so it's good to be here sometimes.
Let's talk though. You want it higher or lower?
No, I was gonna say lower, but I understand. So 5 is fine.
I don't understand how we're having it's normally for a misdemeanor, it's 1 year, but we're changing it to 5 years for this particular crime.
Right, and that's kind of where I was
from the time that you knew or should have known, or is it just 5 years, just period?
Discovery of the video or whatever. You found the video and the clock starts running.
So to me, that could be 20 years later, you find the video and then you have 5 years. I mean, it seems to me like I just feel like we keep nipping away at our basic norms. And why is this different than a sex crime that does have the statute of limitations?
I'm in agreement.
Claire, do you have something you want to add?
I just wanted to clarify, are you saying 5 years from when the victim discovered it, or 5 years from when law enforcement was notified, or something like that?
I mean, I think we were talking about victim discovery.
Curious to hear what Delegate Bartlett has to say.
All right, I'll put my hand back up then. I was going to say, I mean, I get what Delegate Cardin was saying. However, the issue here is technology. It's totally different because there's not a discovery process when you're talking about, something that happens in same space and time. We're talking something that is not easily known or may not be known right away. and not easy to identify where it came from, and who produced it, and so that you can go after the people. So that's the reason why we are extending this as opposed to same place and time type of misdemeanor, in my opinion.
I have to say, Delegate Bartlett, I would give you that if we did it the way we did the funerary objects, where the clock starts running once the crime happened. But if it only starts running once you discovered the crime, I'm not sure that same argument is there. I am sympathetic to someone might discover it and have other emotional reasons or psychological reasons for not pursuing charges. That seems to me a plausible case. And so I think that's the thing, like many of the sex assault offenses that we deal with, people don't come forward all the time. So
well,
I
Mr. Chair, whichever you like, I'll go with
whichever
that.
you like.
Because I like the 5 years, but I'm saying whichever argument works, I'm fine with it.
Well, we need a motion. That's the bottom line. Someone move a statute of limitations number. We'll stick it on the bill and let's get out of here.
Move 5 years from the date of discovery, from the victim's date of discovery.
Second.
All right. All in favor of adding a 5-year statute of limitations upon discovery of the content, raise your hand.
I say aye.
Aye.
Would anyone like to be recorded in opposition? Okay. Now you've got the bill as amended before you.
Move bill.
Second.
All right. All in favor of House Bill 145 as amended, raise your hand or say aye.
Aye.
Would anyone like to be in opposition? Okay. Thank you very much. Last bill.
Thank you, Mr. Chair. Thank you, committee.
Yep. We're going back to see, we're bipartisan here. We're going back to the beginning. House Bill 128. Sandy Rosenberg, legislative witness tampering.
Yes, sitting in for Delegate Rosenberg, who is in voting.
Ah, okay.
Yep.
Can we put this on the screen? No, not that one. Let's get the actual bill text on the screen. Colleagues, I've tried to wrap my brain around a way forward on this bill that adheres to the sponsor's intent to capture non-physical harms. That point seems to raise a lot of questions with members. And if we proceed, it seems to me that folks want a lot more clarity and definition on how to break that out. I do believe, and no one yet has come forward with a model here. We had a few members have had some discussions about other ways to approach this, like immunizing people from various types of actions or whistleblower angles to protect people if they have some retaliation for their participation in a legislative hearing. My part theory of the case would be that if we want to get out of here and at least keep a ball in the air before a crossover, the easiest lift is to strip this down to threat of a physical harm. That if you're actually threatening physical harm on someone, that's a very clean and simple way out. But I concede it doesn't quite match up with what the type of offenses the sponsor was trying to do. But I don't have a better theory of the case at the moment, so I'll open it for discussion. Delegate Eric Hand.
So I'm a fan of the whistleblower protection for people in the healthcare industry, including pharmacy. So I think ideally that would be the direction that we should go, although I do think that's maybe a completely different bill for a completely different committee. I don't love the idea of moving just physical harm. I just don't think it captures at all what they were trying to do. I just don't know that that's really necessary. I mean, threats of physical harm is already a crime. So I just don't know why that would be really necessary. And I guess I'd want to know what the sponsor thinks about that, because it just doesn't feel like it's getting anywhere close to what he intended. And I'd like to see kind of a whistleblower protection vibe instead of this personally.
And you know, in fairness, it's just some of that content is not quite our committee's subject matter jurisdiction. So it's not the easiest for us to try and redraft it this late in the game in that manner. But Delegate Kramer, and then we'll hear from Delegate Rosenberg's office.
Yeah, so I thought the crux of the bill was kind of a coercion against participation as opposed to a threat of physical force or some specific threat. You know, I thought it was more about a person or party being coerced against participation. I thought that was generally the idea of the bill and the direction we were going to go. So maybe the staff can help us out.
And this is Delegate Sample Hughes. I used to be on HGO, and I know that the sponsor was trying to get to the point where the pharmacy benefit managers were retaliating against the pharmacists by taking back some financial benefits that they originally had because they did come and testify. So the physical harm wouldn't get at the bill sponsor's intent. And that's my understanding from being on there and knowing what has happened financially to these pharmacists. And the sponsor's staff person can correct me if I'm wrong.
You wanna weigh in?
Yes, hi, Martha Nathanson, representing Delegate Sandy Rosenberg. Delegate Rosenberg's example came from that pharmacy benefit manager situation. However, I don't believe that his intent is limited to that. So if we were able to capture a threat of physical harm, if that were comfortable for the committee, physical harm to coerce someone to not participate in a legislative hearing or to participate but not say certain things. If physical harm was the only level to which the committee is comfortable, I think Delegate Rosenberg would be comfortable with that. That would start the process. The PBM financial retaliation is another type of harm, but not necessarily the only one that Delegate Rosenberg was attempting to address. Does that help?
It does. And again, I appreciate everybody's comments. So again, this is, if we're trying to keep the ball in the air,
yes,
with an easy lift on the code, that would be my suggestion. We take out the property and the non-physical harms, put it in as physical harm, and probably drop the penalty down a little bit.
I think Delegate Rosenberg is comfortable with whatever the penalty you think would be appropriate.
Well, Mr. Chair, I just want to ask the staff person, has there been physical harm to any of these pharmacists?
We're not aware of that, but
No, this would, again, yeah, this is.
I understand where you're going for the law.
Yeah.
I understand where you're going for the law. We're kind of stretching it. But I was just curious. Thank you.
Chris, would you mind scrolling down a bit on the text in front of us?
And if I may, Mr. Chairman, I think Delegate Rosenberg, we believe there could be a threat of physical harm, even if the ultimate was the financial impact. So that's why I think he'd be comfortable with starting with that. It'll be fine.
And I would have suggested a misdemeanor 3 or something on this instead of 10, but I don't know.
Mr. Chairman, I think those were taken from the statute that currently is in place.
The witness
for-
tampering, right?
For the,
You
right,
did- yeah.
general witness. So if it's the will of the subcommittee to lower that, in this case, I think he'd be fine with that. The drafter just lifted what was in current law, which made sense at that point.
So this is my proposal to get us out of here, guys. We put in physical, we make it about physical harm, and then we pick the appropriate penalty and get out of here.
Move favorable.
Well, let's go one at a time here. Is there a motion on the physical harm and removing the property and non-physical harms?
Move favorable.
All right. Is there a second on that conceptual amendment?
Wow.
Second.
Okay, all in favor of physical harm amendment, please raise your hand or say aye.
Aye.
Anyone opposed?
Oppose.
Wait, hold on. We got to count this.
Oppose.
All right, sorry. We got to do this again. I got caught off guard here. All right, the yeses on that amendment, please raise your hand. All right, that's
Aye.
1, 2, 3, 4, 5. The noes on that amendment, please raise your hand. 1, 2, 3, 4, 5.
Chair breaks ties.
The chair has to break the tie.
I like that amendment. We're sticking it on there.
There
All
you
right.
go.
We got to pick a penalty number now. So someone's threatening physical harm for someone to attend or not attend and testify as a witness in a legislative proceeding. 3, 5, or 10. Those are your options.
I propose 3.
I was gonna go with
Second.
5.
Second.
All right. All in favor of putting 3 on
Wait.
this misdemeanor 3, raise your hand or say aye.
I wanted 3 and 5, but
Anyone opposed to the 3? All right, we got 1. All right, now the bill is before you as amended.
Move favorable, Mr. Chair.
All right, Delegate Erican.
Okay. This is already a crime. I don't understand why we're doing this. Like, it's just a crime on top of a crime. So like now you're in trouble because you made a threat, but you're extra in trouble because you made a threat because someone's going to
Right,
talk to the
which is
legislature. Like,
ridiculous.
You were trying.
I mean,
you
what
were
are we
trying-
doing
you're
right
trying-
now? It's just
Well, no. Look, to be fair, this whole bucket of bills is about people who are tampering with government process, right? It's not just an assault. I just want to be fair to what all of these types of bills are doing. There's the assault, and then if it's an assault that's intended to stop a court case from proceeding, to stop an election from happening, or to stop the legislature from taking its action, that's the argument that you're actually damaging democracy or judicial process on top of the assault. So I don't want to make light of what some of these bills are trying to do, despite the fact that we are doing a little bit of a Frankenstein surgery job here. But having said that, thank you very much. We are on the bill as amended.
Move favorable.
second. You got, yeah.
All in favor of the bill as amended.
Aye.
Would anyone like to be recorded in opposition? Okay. So that's it. We cleared through the docket. Thank you for your
Thank you,
attention.
Mr. Chairman.
All right. See you all tomorrow.
Thank you.